Thank you all very much for being here. I'm very excited about this panel. If anybody has food, feel free to keep eating. We are going to be talking a bit about the Texas Business Court and the 15th Court of Appeals, two new courts in our state that are absolutely crucial and interesting for anybody who is going to practice in commercial law or constitutional law and a few other areas as well. We have an extremely distinguished panel today. I want to start with our moderator, Chief Justice Jimmy Blacklock. Really none of our panelists need any introduction, but if you don't know the Chief, he's served in high-level capacities in the Office of the Attorney General, in the Office of the Governor, and now he serves at the highest level of our judiciary, where the court has confronted a number of issues about these new courts, and I'm excited to hear from him today. On his left is Judge Grant Dorfman. Judge two times over, he's now the Chief Judge for the Business Court, but he also has previously served as a Harris County Judge and as the Deputy First Assistant Attorney General of Texas. Glad to have him with us. On his left is Justice Farris from the 15th Court of Appeals. She had a distinguished appellate career at Yetter-Coleman before joining the bench, and she has the notable distinction of being the only 15th Court of Appeals justice not named Scott. On her left is Judge Patrick Sweeten, also from the Business Court. He had a great career at the Attorney General's office and elsewhere in trial litigation, and had the misfortune to suffer having to teach me much of what I know as a lawyer. So I'm glad to have all of them here. Please join me in welcoming this great panel.
Thank you so much, Will. Thank you, everybody. It's my honor to officiate this panel. And I want to thank the Federalist Society for showcasing our state courts and these very, very important new state courts in this way. And we're looking forward to having a discussion with you guys about the important work that these excellent judges are doing. I know all three of them personally from before the time that they joined these courts. And I want to say with respect to each of them and to their colleagues on both the Business Court and the 15th Court of Appeals, that it is an honor to the Texas judiciary that they have been willing to join us in this capacity, and they are a credit to our branch of government. And we're very, very pleased that they've foregone many other opportunities to take these responsibilities upon them, and couldn't be happier about that. I mentioned that I know them. Judge Dorfman and I both clerked for Judge Smith. And so I've known Judge Dorfman, Judge Jerry Smith, who's here with us, and I've known him for a long time. And that was such an incredible way to start our careers. And I hear that Judge Smith is taking applications for law clerks all the way out well into the future. I hear into the second J.D. Vance administration. So if you are an enterprising middle schooler, act fast. Judge Sweeten and I worked at the Attorney General's office together on all kinds of big cases, and I was always so impressed with him because I was the paper lawyer whose job it was to make sure that the motions and the briefs looked the way they needed to look. And Judge Sweeten could do all of that too, but he was the guy who went into the courtroom and did battle truly on behalf of the people of the state of Texas. And it was an honor to work with him and to watch him do that. And Judge Farris I've known for a while as well, and have admired her career and seen the great work that she's done for our state in many different capacities. And again, both with respect to her and all these folks, it's just, we're just so pleased that people of this caliber would take these jobs on. And with that, let me just give a brief story about sort of the intro, the origin of these courts, and then we'll move on to the panelists. 2015, so Governor Abbott had been elected. I was his general counsel. We had a lot of experience at the AG's office litigating big cases in state court, and that meant cases in Travis County and in the Third Court of Appeals. And we were noodling over ideas, and it was late in the bill filing period in the 2015 session, and Jay Dyer, who was the governor's legislative affairs guy, who's a wonderful, wonderful man, he said, well, why don't you, come up with a bill and we'll take it over there, and maybe there's something we can do about this. And so I remember walking across the Capitol grounds with a physical piece of paper to the office of Mike Schofield, and the bill that we'd written up was the Texas Court of Appeals, and it was also the Texas District Court, and it was sort of patterned after the D.C. Circuit and the D.C. District in the federal system. And it got filed, and then it was just there on the internet. I don't think anybody looked at it or thought about it. The business court was a much more discussed idea. But my point is that these ideas start as just kernels, just ideas in people's minds. You push them forward. You don't always succeed. It took several sessions. It often takes several sessions. It takes a long time for these ideas to come to fruition. And the idea of these new courts did come to fruition a couple of sessions ago. So let's start with Justice Farris. Tell us about the 15th Court of Appeals. How did it come to be? What's its jurisdiction? Why should the people in this room and all of their fellow Texans care about it?
Well, it's funny that our name is the 15th Court of Appeals. We, of course, are sequentially the 15th Appellate Court created in the state of Texas. But one surprising thing is it's kind of an understated name for the types of work that our court handles. So we have, I would divide our jurisdiction into what I would call buckets, and now perhaps cups following the last session. But our three main buckets of jurisdiction are cases, appeals from the new business court. We're very excited to get those. But we also have a couple of other very important buckets. And one of those is litigation involving a state officials, state agencies, state university systems. There are a whole bunch of carve-outs. For example, we don't do eminent domain. We don't get Tort Claims Act. But a lot of that state litigation comes straight to us, and that administrative docket that used to go to Austin also comes to us. The other bucket that we have is also a pretty big bucket. It's constitutional challenges where the AG is a party. So between all of those buckets, we're very busy, and it's so funny because our name is just the 15th Court of Appeals, and so I think a lot of people don't realize what all we do. Some people think we only do business court, and in fact, when I actually took the job, I was telling my mom about it, and she's not a lawyer, and she's like, wait a minute, you're going from the first court to the 15th? April, this is a terrible idea. Why are you doing this? You're number one. And I was like, no, Mom, this is going to be okay. And she's like, well, I still think this is a very bad idea. But we are very excited to get to do this work. A lot of states have business courts. We are the only court that has an intermediate court designed just to handle business court cases, and that's going to solve a lot of problems with making sure that whatever comes from our business court in terms of efficiency and consistency doesn't get lost by being shipped out to various appeals courts where you're going to get a lot of fractured decisions. So that's us. And then in the last legislative session, the legislature actually added some new things to our jurisdiction, which I call the cups and not the buckets. And those are very exciting things like municipal lot size and things like that. So stay tuned, and maybe they'll add some more to us later on.
Now for the business court, tell us, Chief Judge Dorfman, about the business court and why it's so important.
Well, I'm going to borrow Justice Farris' buckets. We have three main buckets that comprise our original jurisdiction, at least as of last year. We started September 1, 2024, and I was very mindful, I think we all were, the 10 of us business court judges, that unlike the 15th Court of Appeals, which started on day one with an inventory, all the other courts, 1 through 14 Court of Appeals, were ordered to transfer their administrative law cases to the 15th Court on that day. We had 0 cases when we opened for business, and my nightmare scenario is we would just be sitting in our office, sitting in chambers and hearing crickets chirp and nothing else. Fortunately, that hasn't eventuated. But we are a court of limited jurisdiction. We have almost no exclusive jurisdiction, and everything we do is concurrent with the state district courts, sometimes the state county courts. So you don't have to file in the business court. You have to want, and we're very mindful that our customers need to want to be in our court, and we try to make it a consumer and customer-friendly court for that reason. The three buckets are corporate governance and internal governmental disputes with over $5 million in controversy. This I kind of call the Delaware bucket, the kinds of things you're used to reading in your papers, law.com, about the Delaware Chancery Court decisions. And the second bucket is all of those cases with no dollar minimum required if the company at issue is a publicly traded company. So there's no dollar threshold there. And then the third bucket is just what they call qualified transactions, which has a fancy definition in the statute, but more or less means a business dispute with over $10 million at issue in the business transaction. You buy or sell property for $15 million, you qualify if you have over $10 million in damages. And just last week, the legislature, in the last legislative session, changed that to a $5 million transaction and over $5 million in controversy, which we expect to bring a whole nother class of cases within our concurrent jurisdiction.
I'll note that that was all off the top of his head without notes.
Been doing this for a while now.
Judge Sweeten, you've, as we talked about, been a successful courtroom lawyer, litigator for many years in many capacities, but this is your first time as a judge, and it's different, obviously. How have you found it?
So we're now 1 year in. I have found it's really kind of a dual role, because as Grant referenced, we are building a court, a structure of a court where we voted for a chief. We've been hiring staff, briefing attorneys, law clerks, and sort of setting up the infrastructure of the court, adopting local rules, adopting administrative procedures, adopting, just sort of setting up how the framework of the court is going to run going forward. Then there's the courtroom part of it, and that I have found really interesting. It is different, but fairly similar, being a referee of the disputes. Many of the disputes that come to me are obviously discovery disputes, and those I'm very familiar with, and then certain other things are areas that I have to learn about. But I've found it very challenging, very interesting. But I like sort of the dual aspect of the job. And I'm just honored that I was selected, and I've had a fantastic first year. So thank you.
So that's the perspective of the new judges, Justice Farris and Judge Dorfman. You were judges before, and when you joined those courts, of course, they were existing institutions that had courthouses and courtrooms and procedures, and you can just sort of slot yourself into things as a new judge. But that wasn't the case here, being the first judges on a new court. And so tell us about some of the challenges and maybe opportunities that you faced in that capacity.
Who goes first?
Go ahead.
All right. You put that very well. I was very mindful. I've been appointed twice before, both times by Governor Perry, to state district court benches in Harris County, Houston. And like I said, everything was there for me when I got there. I had courtroom, I had chambers, I had staff, I had cases, lawyers, bailiff, court reporter. All I had to do was buy a robe, put it on, manage not to trip on it on my way up to the bench, and I was fine. We were very mindful. This was a very different experience. And so, like Patrick said, we went about creating the court. Logistics, I was interviewing court reporters on Zoom even before our court opened for business, so that we'd have that transcription ability. But law clerks and all that came later, and finding out we've all, there's 10 of us, 2 each in our 5 largest cities, Dallas, Fort Worth, San Antonio, Austin, and Houston. And we each kind of had to come up with our own arrangements as far as where we would have our hearings, where we'd try our cases, where we'll office. We were lucky in Houston, and I'm very grateful to the Courts of Appeals, the 1st and 14th, to find space for us to office and to let us use their courtroom when they're not using it for our hearings. In the old 1910 courthouse, the Fort Worth judges are in the Texas A&M Law School. Patrick and his co-judge here have great office space in State Building, and the Sweat
Clements Building and the Sweat Courthouse.
And the Sweat Courthouse, the old Travis County District Courthouse, they have use of that. So it's all different ones. But yes, I tell people that we're now at a point 1 year in where the level of judging, because all of our cases were brand new, we didn't take any cases that predated our court, so we've kind of grown old with our cases, or rather they've grown old with us. So all of our early opinions were jurisdictional in nature, and now they've gone kind of through the civil procedure book, the rule book, to where then we had 91As and then summary judgments, and soon we'll be having trials. So we're progressing, but it's worked out about as good as one could hope in all the concerns I had there. So really, we're just now getting to where we're having bench trials, having jury trials, and fingers crossed that all works to plan.
I'm glad to hear it's going well, because if it weren't going well, that would come to the Chief Justice. And so thank you for taking care of all those issues and that haven't had to come to me yet. The 15th Court of Appeals, what's been your experience on the new court, Justice Farris?
Well, we like to say that we're building the airplane while we're flying it. And on the 15th Court of Appeals, we believe that the courtroom is a state of mind. And the reason why we believe that is because the legislature didn't give us one. So we are a courtless court, but we are kind of using that to our advantage by doing a bit of a roadshow. So we are an appellate court for all of Texas, and we are really trying to make that a reality. So we are hearing cases at UT Law School in their beautiful courtroom there. The Court of Criminal Appeals has been very generous and let us have sittings in their courtroom. We're about to go to Texas A&M Law School in October to hear cases there, and then we're also working on setting up something at Texas Tech School of Law for the spring semester. So if you'd like us to come to your law school, we will make it happen. Beyond that, one of probably my favorite things about setting up a new court has been hiring staff. When I was in the first Court of Appeals, we just inherited our staff, and I inherited some great staff attorneys, and I've really enjoyed working with them. But on the 15th Court, we've all been able to hire our own folks, and I'm really excited to say quite a few of our past, present, and future staff members are here today. So my staff attorney, Kavod Singh, one of Trop's finest, is back there. I've got my former law clerk, Maha Gaius. I just saw her. And then my incoming law clerk for 26-27, William Clutterbuck, is coming from UT. And so we've got a great crew here. I've also seen a couple of the current 15th Court law clerks, Carson Schwertner and Mark Shoris. They're both with us. Carson's with Justice Field and Mark is with Chief Justice Brister. But we are very committed to hiring law clerks. So we'll each take one law clerk for every year. So if you know law students who really love administrative law and constitutional law and challenging business court cases, please encourage them to apply.
Yeah, I've heard it suggested that these new courts, maybe we didn't need them because there weren't going to be enough cases for them, not enough for them to do. Talk about that. Has that been your experience of all of this, Judge Sweeten?
Sure. So the court came about, there were about 2 decades that proponents of a business court for Texas have been trying to have one adopted. And finally in 2023, with a lot of forces coming together, the governor, the lieutenant governor, the Speaker of the House, and Chief Justice Hecht, the bill was passed. And with that, and obviously there was a lot of testimony during the legislative process about the need for it from the business community and advocates. Well, that's borne out over the last year, because over the last year, in 1 year, we had 187 filings. Now, keep in mind that as Judge Dorfman said, these cases primarily are over $5 million complex litigation cases. That experience in 1 year compares very favorably with other business courts that have been established throughout the country. Here, I mean, it's not a perfect data point, but one data point is the North Carolina Business Court, which in 1995 was established. So it's been there for 30 years. And their average, and though its population obviously is not the same as Texas, they are averaging right now 52 filings per year. Our statewide court at 187. And so I think, the testimony was the legislative efforts were, if you build it, they will come, and they have come.
So another aspect of being on these new courts is that the basics of your jurisdiction, which you laid out earlier, are contested, perhaps unsettled, subject to litigation, and even the existence of your court might be subject to some kind of a challenge, perhaps. Tell us about, how you deal with that, Justice Farris.
Well, I am very excited to say that we had the constitutional challenge to our court before I was on the court. So the Edry Dallas County decision came out from the Texas Supreme Court, Justice Young authoring the week before we started. So I always tell people I was really glad we waited to get those 15th Court tattoos until after after that decision came out, finding us constitutional. But I would really encourage you all to go read that decision because it highlights so many unique factors about our Texas courts that other states simply don't have, like a lot of shared jurisdiction between intermediate courts and counties that fall into both. And a couple of the questions that were decided in that, one provision of our Constitution, Article 5, Section 6A, says that the state must be divided into Court of Appeals districts. And one of the questions well, the 15th Court is the whole state, so how is that constitutional? And the court found that the legislature has already fulfilled that. The state is divided into Courts of Appeals districts. We've got 14 of them, and overlapping jurisdiction has been with us for a very long time. In fact, the 1st and the 14th courts have shared the exact same 10 counties for quite a while, and it's really interesting. I tell people the 1st and the 14th are like a good marriage. They live in the same building, they have the same constituency, but they don't review each other's decisions. So we have a lot of unique features like that, and the Texas Supreme Court said that the 15th Court fit right into that. And also they looked at the question of whether you could give one court exclusive jurisdiction over something like the administrative docket. And what the court said is, well, the 3rd Court of Appeals has essentially already had that all along because of what types of cases have to be filed in Travis County. And so if you can have one court that's selected only by the people who live in the Austin region deciding those issues, then there's no problem with having a statewide court decide those issues. So we're very glad we're constitutional.
Judge Dorfman?
Well, there was speculation as to a possible challenge both to the 15th Court of Appeals and to the Texas Business Court when the legislation was first proposed. When it came out, I think State Bar Advocate magazine had a number of articles pro and con on the constitutional issues for good or ill, while the 15th Court, and I actually absolutely commend Justice Young's and the Texas Supreme Court's opinion. It is like a good, quick history lesson on the structure and history of the Texas judiciary. Great read. But the business court has not yet had a challenge. Is this wood? You just hit that for me. I'm going to knock on wood there. No challenge has been raised by that, and I think there's a different ideological component, perhaps, that makes a challenge more likely, perhaps, to the 15th Court of Appeals. But I'm speculating rampantly. A UT law professor, I think the policy here is the names shall be protected, both good and the innocent and the guilty. But a UT law professor wrote an article speculating on grounds for a challenge and proposing the business court could be challenged on the grounds, and I may get this a little wrong because it's not as front and center as it used to be for me, that in Texas, the Constitution more or less makes it clear that district court judges must be elected by the voters. And the business court judges are structured to be appointed by the governor, subject to the advice and consent of the Senate, just like on the federal side, to 2-year terms, at least currently, and subject to reappointment every 2 years. That is obviously different, and the argument was effectively that the business court is, in essence, a district court. This parts of the legislation says that we have the same powers and privileges as district court judges, and that was blown up in this argument. That said, my introductory remarks make it very clear, I think, that we have very limited jurisdiction compared to a district court, which has residual, not only broad jurisdiction, but residual jurisdiction as well. So I think that would be where the argument takes place. Again, we've not yet had a challenge to the court.
So because the structure and jurisdiction of both of these courts is primarily statutory, it could change anytime the legislature comes into session. It could be expanded, constricted perhaps. Or have you all heard of ideas along those lines? Are you watching any such proposals?
Yes, and in fact, they've happened. So as you know, the 88th legislature created the business court, and then the 89th made some adjustments to the jurisdiction of the court. One of the, I think all 10 of our judges ruled on jurisdictional challenges that sought to bring cases that were pre-2024 filed cases over to the business court. I think we uniformly rejected those efforts to bring those cases because of the statutes, Section 8 of the original statute. The legislature came in and now is allowing jurisdiction if it's jointly agreed to by the parties for pre-filed cases, and of course agreed to if the judge approves it. And so that has opened the door for those. The court, the legislature also, they increased our jurisdiction. We used to have a 10 million threshold limit for qualified transactions. They lowered it in the last legislative session to 5 million. So we expect those, jurisdiction, that there will be some tinkering with the jurisdiction of the court, as it goes along, and they've already done that.
Let me add on that point, one of the minor tinkers with our jurisdiction has been geographical. Originally, it was decided the court is not statewide. It is actually, as I said, 10 judges, 2 each in our 5 largest cities with a radius based on the regional judicial administrative districts. I don't know, probably 5 of you know what the regional judicial administrative districts are in the state, but it was a geographic shorthand of convenience to structure the court so that ultimately, if it goes statewide, we'll have the 6 other regions that were left out. There are 5 regions centered on those major cities with counties around them, just like courts of appeals districts are. So I have 6 other counties. You've got 20-something other counties in the Austin court. But each one's kind of different. Because that was the shorthand chosen, it doesn't line up perfectly with what they were trying to accomplish, which is to have the whole Houston Metropolitan Business District in the Houston court, and same with Austin and Dallas, et cetera. So this legislative session, they tweaked it a little to take Bastrop, which is in, I think, the 2nd judicial region, which doesn't have a business court, put it in the 3rd business court solely for that purpose, Bastrop County, right outside Austin. And then in Houston as well, we have Montgomery County, which is just due north of Houston, has a lot of energy companies, oil and gas companies there. Exxon is just on the border between Harris County and Montgomery County. And so they've added that, even though it's also not in our judicial region, into the Houston Business Court Division.
So the business court, as you might imagine, has been compared to the Delaware Chancery Court, which I guess has recently come under some criticism, and there's a sense out there that maybe in terms of corporate law in Delaware, the bloom is off the rose or coming off the rose. How does the creation of the Texas Business Court play into that, and what does Texas have to offer that Delaware does not, other than we're not a suburb of Philadelphia? Judge Sweeten?
So, I mean, I think this was, the criticism of Delaware was crystallized in and I looked it up, an Elon Musk tweet of January 30th, 2024, where he said, "Never incorporate your company in the state of Delaware." And I think that was after a ruling related to Tesla compensation. But there has been, a reported growing sense in some quarters of the business community that the certainty and predictability may not be as prevalent as they've grown accustomed to. But aside from, Delaware's jurisdiction, I mean, I think I want to talk a little bit about, what are some of the efficiencies of the business court in Texas? And part of the, what we have to offer, what the business court has to offer is there are 10 qualified judges. We've adopted procedures much like a procedure adopted in North Carolina for trying to have discovery disputes handled by, short filings, letter filings. We've adopted procedures for having some matters to be heard by Zoom. I think expediency is something else that I think we offer. Our cases are now, after a year, and because we started with kind of with no docket, they are now starting to reach a level of maturation, and we're getting busier. But I think what we're endeavoring to do is to make bench trials is to set them and try to have them adjudicated within a 12-month period, and then for jury trials somewhere in the nature of 18 months. And that's not always going to be uniformly possible. There are discovery issues; those things can change. But we have sort of a goal of having those cases, through discovery process, motion stage, and everything, try to have them adjudicated in that amount of time. One of the things that we think that the Texas Business Court does bring is that very certainty and predictability. One of the requirements in the business court statute is that we issue written opinions regarding matters important to the state and matters and dispositive matters upon the request of the party. So, we will be issuing opinions. Those opinions are posted online, free for anybody to go see, for a general counsel to look at. How would the business court decide this case? And then another real feature of it is sitting, 1/3 of it is sitting to my right, which is that we have one appellate court. The way that the business court was structured is that all of our appeals go up to the 15th Court of Appeals. And so they will be speaking with, presumably, a consistent voice on the matters that we decide, and correct our errors. And through that, I think you're going to have a level of consistency in business litigation jurisprudence in the state. So, and I think there's another important, point here, because our docket, it's a specialty court that was established to, kind of take these cases, or at least give the option to take these cases from district courts, state district courts in Texas. State district court judges are very busy. There are statutes such as, that require them to hear certain matters, like CPS cases. They have to give priority to those. Many district courts, in many of the counties that we cover, not in Travis County in particular, but within our judicial region, many of those courts have criminal dockets and there are traffic issues. And so they have a whole host of cases, and with the statutory requirements, sometimes these cases, these kind of complex, complicated business cases, get pushed to the back burner. And I think what the purpose of this court is to give those some priority in our courts, and so we're designed to work in tandem with our district court partners, not in opposition in any way to them. I think that covers the efficiencies of the business court from my perspective.
So, Judge Dorfman, a while back I was saying something very nice in public about the business courts, and somebody came up to me afterwards and was not happy at all with what I'd been saying, and so someone who I assumed would be supportive of me, and they let me know that I was making a grave error by calling it the business courts, plural, because it is the business court, singular. And so after getting over the initial sort of blow to my ego of being chastised in that way, I had to admit that they're exactly right. That person was exactly right. That is a very important distinction. But Judge Dorfman, why does it matter that this is the business court, singular?
It didn't have to be that way. I think, and I want to give credit to the governor's office, general counsel, who interviewed and selected. This sounds ridiculously self-serving, so forgive me. But I think on the whole, they did a good job picking 10 people for these judge positions, in as much as you get 10 people, much less lawyers, much less judges in a room. and you're going to have one or two who, shall we say, can be challenging, difficult, if only temperamentally, personality-wise. We haven't had that. We didn't know. I knew Patrick, of course. I knew one or two others of my now colleagues before their appointments were announced. But the first time we sat around a room was just a little over a year ago for our first business court meeting. And I think we discovered to our delight that we're like-minded, and we're like-minded not just in how we approach the job, but in work ethic and all that, but also in how we have a vision for the court, as a uniform experience. It can't be, obviously, your Judge Sweeten's going to be different. He's going to have different pet peeves than Judge Dorfman, than Judge Adrogay. But for the most part, we've worked hard from the beginning to create a uniform experience, realizing we are trying to attract people. No one has to be in our court. It's a choice. And so we want to attract those cases back into the court system that have gone to arbitration, into the business court if they're sitting in district court and maybe can't get a hearing, can't get a trial, sitting behind cases that have and maybe well-deserved priority. They're our priority. So we'll give them it's never going to be cheap to try $5 and $10 million cases. It's not going to be fast in all cases, but relatively inexpensive, relatively fast, certainly efficient is a pledge we've all made. So we've developed local rules, kind of like Justice Farris' example of building the plane while in midair. We've been making it up as we go along, but we've made a lot of progress. And we had that maturation of our cases that allowed us the time, I think, to really think about how we wanted the experience. Our local rules, I think, are 4, maybe 5 pages now, 10 rules. It's not a phone book like the North Carolina Business Court, the Georgia Business Court, 68 pages of local rules, where what happens is the senior partner on the case throws that book at the youngest associate and says, learn this, make sure we don't screw up, and never sees them again. So we try to keep it as much of a user-friendly experience as possible. And I think part of that is the uniformity of it being the business court. Judge Sweeten's decisions, enlightened and brilliant as they are, aren't binding on me, just as the Southern District of Texas, an individual judge isn't binding on his or her colleagues. And that's where the 15th Court comes in. But we do want it to be a uniform user experience and business-friendly, customer-friendly in that sense. Hence the court.
Judge Sweeten?
Yeah, I think that's right. We are trying to make it a user-friendly experience. I think we're and I think we're sensitive to, many of us, we kind of come from various disciplines. I think 4 of us are former judges, Judge Dorfman being one. We have some from the appellate bar, some that kind of come more from the trial bar. We have a great group of judges, and I think I think we've worked well together. One thing he did not say is that for us to come up with 4 pages of local rules took 10 judges, 10 meetings, and so
we started at 25 pages. Fair to say.
But we got there, and I think we've all worked very well together, and so yeah, I think it's a good group. We're establishing the framework for the court, and so far so good.
So I want to turn to Justice Farris, and the 15th Court of Appeals has aptly, I'm sure, been described as the DC Circuit for the state of Texas. Certainly some similarities, but is that the right comparison, do you think? And how do you see your court affecting the future of administrative law in particular in Texas?
Well, I'm going to go home and tell that to my mom, and maybe she'll feel a little bit better about what she's been referring to as my demotion. But I think we actually have an even more interesting docket than that court because of all the different types of things we get, including the business court litigation. But I mean, we're at a Federalist Society conference. We all care a lot about administrative law, or at least we pretend to. And it touches every aspect of our lives. If you want to drive a car, you've got to go get a license for that. If you want to sell alcohol, you have to go get a license for that. If you want to engage in the ancient art of eyebrow threading, you won't need a license for that, thanks to our Texas Supreme Court. But it really is very expansive and covers a lot of our lives. And so I think it will be a real opportunity to develop the law, especially kind of in this unique moment. You may or may not know that the Texas courts have never really adopted Chevron. Chevron's, been the federal rule until Loper Bright.
Stand up, Josh.
Thank you. Getting an A+ from Professor Blackman over there. So far, so good. But we did have a case law that said that an agency was entitled to deference if the statute is ambiguous and the state agency's interpretation is reasonable and doesn't conflict with the statute's plain language. This was kind of a recognition of agency expertise. But in the last legislative session, there was actually a new law that passed that requires courts to review agency interpretation de novo without agency deference. And I'm not going to, I'm sure that will come before us at some point, so I'm not going to go into what I think
We
that
could have
may
a whole panel on
be
statutes purporting to tell the courts how to interpret statutes. That's for another day, I suppose.
Yes. So basically, it's going to be a very interesting time to be in Texas administrative law. So stay tuned.
Yeah. I mean, it's just a topic that you might not have thought 20 years ago you would ever be reading about. You open up the newspaper and there's Chevron deference, and there's the major questions doctrine, and there's non-delegation, and these topics are so timely and so important, and as you said, have such an effect on the way we're governed and on people's everyday lives, and it's very, very important work. Let's see. So for Judge Dorfman, Federalist Society, conference, business court, what do you see as the sort of overlap between your work and the mission of the Federalist Society?
When they first announced this panel, I stressed over this very question. I drew up a lot of material and prepared candid, forthright, no punches, no holds barred. But then the first speaker today announced that the Federal Society has reincorporated in Texas. So I have nixed all that. Not going to go forward on that. Don't want things quoted back to me should we ever have the pleasure of the Federal Society in the Texas Business Court. But I do think, in all seriousness, that the business court shares in some respects the mission, the creation of the court itself, addresses some of the frustration I certainly experienced. People assume I wanted to be a Texas business court judge because I'd been a judge twice before on the district court, and that's not false. But the truth is, in between those judge gigs, when the voters in their unwisdom saw fit to return me to the private sector, I worked for 5 years as an in-house attorney supervising worldwide litigation for Neighbors Industries, a drilling contractor, and found to my chagrin when I got there that our forms manual invariably, whether you're in Saudi Arabia, Russia, Algeria, or Colorado, our favored dispute resolution provision was arbitration. Our second favored dispute resolution provision, if you couldn't get the first one, was also arbitration, just a different type of arbitration, and so on down the line, so that when you're sitting across the table from an 8,000-pound gorilla in Chevron, Exxon, Saudi Aramco, this is what we want. And I thought, look, I don't have a great love for the court system right now. They threw me out. But still, it's a relative bargain compared to private judging. And if you get a judge who refuses to follow the law, as shamefully sometimes you do, you appeal and you get good jurists who are committed to the law. The further you go up the court system, the more assurance you have of that, I think, generally. And you can get your contract or your business deal vindicated. If you go into arbitration and you get an arbitrator that refuses to follow the law, you cut a check and you're done. It's over. And that we had that experience often enough that I was a real proponent of this. And I think that's the goal here, is for the business court to bring back those cases that have gone to private judging. So fidelity to law is something I think every Federalist Society member subscribes to and can support. And I think textualism is one thing when you're talking about Constitution and statutes, and fidelity to a good faith interpretation of the meaning of what the legislators were striving for. Our law is private law. When corporations contract with each other, as we did with drilling companies, with oil and gas companies, we had decades of experience that told us where when these things go off the rails, they go off this way. So we're going to put into our contracts anticipatory provisions that if this thing goes bad, you've got this indemnity obligation, we've got this counter indemnity obligation, et cetera, and so forth. From years and decades, and if not longer, of experience, and to go into court and find those just ignored routinely, summary judgments denied out of hand, so frustrating. So I think the business court will be a textualist in that sense. And again, textualism being a fundamental tenet of this society. And then interpretive deference, another one. We defer to lawmaking bodies. I think our 10 judges are very much of that mode where we recognize, and we see it each session. SB 29 is a new bill that fundamentally affects, and the governor's written a Wall Street Journal editorial I recommend to everybody on this, that seeks to give cure some perceived abuses that have gone on in other states and other jurisdictions in corporate sector, derivative lawsuits, et cetera. And that substantive law is now something we'll have to interpret for the first time. It'll be interesting to see how that goes out. But I think we're clear that our job is to strive for good faith interpretation of what the lawmakers have written based on the text of the statute. And that's FedSoc 101.
Absolutely. Justice Farris, switching gears just a little, we've got, I'm sure, several law students, certainly a lot of recent law students here. If you had 3 wishes for improving legal education in America, what would you wish for?
3 wishes, I would say, make it more affordable, make it practical, include more opportunities for actually getting courtroom experience as a law student. I benefited from some of those experiences myself. But probably the biggest suggestion I would have would be for every law student to have a thorough and very substantive course on the First Amendment. So as we're seeing, what's going on in the United Kingdom these days, and we're seeing, people, I think they said something like, 12,000 arrests based on social media posts. We really are at a pivotal moment where we need to understand what our First Amendment freedoms are. And I taught First Amendment thanks to thanks to Professor Blackman at South Texas, who talked me into it. And it was just such a tremendous experience to get to share what our First Amendment is about with a generation of law students. In fact, I actually have all of my law students memorize the First Amendment so that they'll have, a neat party trick at dinner parties, and or maybe make them feel like big nerds. I'm not sure. It's gotten mixed reviews, but we start, the class and see who wants to recite. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. And it is so vitally important, especially with what's going on in the wake of, the Charlie Kirk assassination and everything, for people to understand what those First Amendment freedoms are about, and that we can dialogue and that we have the freedom to talk to each other. I actually got to watch for Constitution Day a great presentation by Professor Blackman where he showed video of what it was like when he went to CUNY Law School to give a talk on the very controversial subject of the First Amendment. Believe it or not, he had protesters, carrying signs saying, the Constitution is white supremacy and objectivity is oppression. And it was just unbelievable that these were law students. This is not, just college kids. These were actual law students who just simply had no idea what those freedoms were all about. So I would love to see not just law schools, but also potentially college campuses, high schools, public high schools, private high schools. Everybody needs to take a course on the First Amendment to understand what our freedoms are all about.
Thank you. And I guess finally, before we take questions and really along those same lines, I mentioned earlier that all three of you and your colleagues have many other opportunities. You didn't have to take the oath that you took, but we all took that same oath to preserve, protect, and defend the Constitution of the United States and of this state. And our job is to do that independently, by which I mean independence from other branches of government and from political pressure, but not independence from the law, which of course binds us, whether we like it or not. And our job is to follow the law and the procedures of our courts, no matter what the consequences is for ourselves, political or personal. And we've seen recently the courts of our state, and in particular the justices of the 15th Court of Appeals, have to deal with some just baseless and really regrettable and frankly ludicrous attacks from certain quarters in another branch of government. And also on our minds, as Justice Farris mentioned, is the assassination of Charlie Kirk, which among its many other enormous implications has, I think, caused all of us whose job it is to stand up in public for the law and for the truth, to think more about the dangers that we might face from people who don't like or don't understand what it is we have to say or what it is we have to do. And so just as we sort of come to the end here, I just want to give you all an opportunity, if you'd like, to just tell us a little bit about how you personally navigate those pressures and the many other pressures that you face as you try to faithfully discharge your oath.
That's a great question. I'm going to say it's a great question anyway, but it really was, even though it's Chief Justice. Grades my papers, as does this one. But I go back to what some of what Justice Farris said about the law school environment, and I'm reminded also of what Justice Young said. I was fortunate enough to catch his remarks to South Texas College of Law this week on Constitution Day. And he said, we don't talk about truth enough. Forgive me if I've gotten it, if I paraphrased too much, but we need to talk about truth more. And I think one of the most corrosive aspects of our legal academic establishment was there when I was in law school, almost a century ago now. But legal realism, which was the hallmark that put Yale Law School on the map back in the 1930s, slid into critical legal studies, which many of y'all have suffered hearing about, and now I think has spread out. We called it moral relativism. We didn't call it woke back in the day, but political correctness maybe, and it has suffused not just the academy, not just the legal academy and lawyers, but the whole public, with the notion that truth is relative. There are multiple truths. You have your truth, I have my truth. And that's absolutely corrosive. And I'm not sure I'm answering your question.
I believe you are.
Okay.
I believe you are.
But I think that's one of the great, to back off of that deep subject, one of the great liberating aspects of moving from being a commercial litigator, trial lawyer, to the bench. It's been a long time for me. It's over 20 years ago I did that for the first time, but is to set down the obligation to serve your client's interests, and zealously and correctly and rightly. That's our duty and that's our fiduciary obligation. But to put that down and search for the truth, and how liberating and how great and what a privilege it is for us to be able to do that as our jobs. And sure, there's politics, and sure, there's positions you may take that may be unpopular and may come back to bite you, but I think that core conviction has to be that this is a privilege and an honor, and the Federalist Society is a great bulwark against all those corrosive effects that try to say there's this truth and that truth, and law is just power by phony words that we use to hide the exercise of power, and to stand for that, and just to take the position. Look, I'm grandstanding, and I'll shut up now, but this is the business court. Whether I rule for Chevron or I rule for Anadarko, there's not a whole lot of politics involved, and I don't expect to be criticized for much of that. There may come a case that's controversial in our courts, but these two and the other judges here in federal and state have shown moral courage, and I'm sure will continue to show moral courage and counter that otherwise lamentable development in our society.
Well said. Thank you. Any other thoughts from the panel?
I think that's very well said.
Very
right.
well said.
Great. Thank you. Thank you all so much. Do we have time for questions, I think? Will? All right. Don't be shy.
Microphones.
Yes, sir.
So, first of all, let me say thank you. As a corporate law scholar, not only for this panel, which was great, but more broadly for the efforts of folks like you to implement this. And I'm particularly thankful because I have been mulling over proposing this back in my home state of Alabama as well. Part of the reason for that, I think that it sort of makes for my question, is back when I was a law student at Yale, I had Judge Ralph Winter from the Second Circuit. Roberta Romano was in the building as well. And they were amazing proponents of the idea of states being the laboratories of corporate law. And frankly, you can't have them be as effective laboratories if there's only one state that everyone's focused on. And I'm an elected member of the American Law Institute. We are currently preparing a restatement of corporate governance law. And sometimes when I go to those meetings, it feels like a restatement of Delaware law. I think the observation was correct that in terms of attracting business more broadly to the court, Delaware may be possibly falling a little bit more out of favor. But I want to kind of run something by you that I've seen the Delaware judges do and see if you're doing something similar or might consider it. I have found that the Delaware judges seem to pop up either the chancellors or the Supreme Court justices in almost every major corporate law meeting. And part of that, I think, has been kind of them being salespeople in a way for their court. And I think clearly by the nature of the jurisdiction you have here that people don't have to come to your court, I imagine you're doing a lot of these kinds of events in Texas to attract actual litigants. But I'm kind of curious if there is a plan, what you're doing to kind of attract people from outside of Texas and maybe think about like Elon Musk, reincorporation, and so forth.
Yeah, I tell people who ask, most of what I've been doing the first year on the court has been marketing. Not something judges are used to doing. Maybe if you're running for office, certainly you market yourself to the voters. But we've been marketing the court. We've been doing a lot of CLE, but also outreach to business groups, organizations. I spoke to the Chief Litigation Counsel Association, which is like the people who supervise the civil litigation docket of Walmart, McDonald's, GM. Great opportunities, more listening. I was more keen to hear what they had to say than they perhaps to hear from me. But we're absolutely mindful of that. There's an American College of Business Court Judges that is sort of a warehouse of information and best practices that we've joined and attended their annual event. The next one's in February. One of my colleagues, our colleagues, Brian Stagner, Fort Worth Business Court Judge, just spoke at a symposium in New York City. Just this, I think yesterday, Thursday, lost a day there. So we're absolutely very much focused on that. But Kenneth, I'd be keen to hear your thoughts on Delaware if you want to share.
Yeah, so maybe I'll be politicking the broader audience on that, but I'm happy to kind of talk a little bit more about that later. But I do think ultimately, right, because we have a federalist system of incorporations and people have a choice of where they go to, one of Delaware's key advantages, I always tell my students, was that they had a sophisticated court system that almost was as important as the law.
Yep.
And I think so maybe I won't be as politic, I'll say something about Delaware law, that, in prior years, one of the things I point out is how quickly, when an opinion came out that maybe got a little bit of an uproar, there was reaction, there was, movement by the legislature, whatever. I think to the extent, and there is movement in the law now, it's not for those reasons. And that's why I think they're losing their edge, and why I'm excited that maybe there are going to be some other voices in the broader dialogue on these issues.
You brought up Ralph Winter, also my corporate law professor. Wonderful man, great teacher, hilarious stand-up comedian on the side, and on the short list for Supreme Court justice in the mid-'80s as well, and would have been a fantastic Supreme Court justice. But he inculcated in all of us a great respect for Delaware, and what I perceive as their 200-year head start on us, with a very well-developed body of corporate governance, corporate law precedents to guide the conduct of corporations who are incorporated there and to give clarity. I'm mindful also on Thursday, one of their judges, a vice chancellor, lamented and was quoted in Law 360 as lamenting the annus horribilis, forgive me if I butchered that Latin phrase, but the horrible year and multiple years that they've been having because they come out with kind of left field decisions, some would say left wing decisions, not me, but left field decisions that the Supreme Court reverses or the legislature overrides in the next session, and then the courts don't always take the legislature's direction and maybe ignore it for a while. So if they're frittering away that 200-year head lead with some inconsistency and unpredictability, our hallmark has been stability and predictability, and if they fritter that lead away, that's to our advantage. And I'm also mindful, I meant to say this in my remarks, left it out. Part of our charge as a business court in the 15th Court is to build a body of case law so that we do have that rival guide to private actors. Is here's how your case is going to go. Maybe you don't even need to file a lawsuit because how this would play out in the court system is so clear. And that's one of the reasons why we only alone of trial courts in Texas actually are charged to write opinions, at least in our dispositive cases and dispositive rulings in any cases that have significance to the jurisprudence, certainly the business court, corporate governance jurisprudence. So we're looking forward to doing that as well.
Right. I'll just chime in, and yeah, we have all been engaged. All 10 judges have been engaged in quite a bit of outreach. I think your point about the written opinions being easily accessible for anyone to read. And you forgot, Justice Dorfman, Judge Dorfman, that we wrote a journal article and have written several about the operations of the business court and the history of the business court and that sort of thing. So we're writing, we're doing all we can. I actually spoke at a CLE in this very building yesterday on corporations, LLCs, with my co-judge, Judge Andrews here in the 3rd District, and we have been asked. There's a lot of interest, and I think it's incumbent upon us to make sure that practitioners in this state are educated as to what is our jurisdiction, and the operations of the court, and we are engaged in that endeavor. So thank you.
Well, I think you're spot on. People are looking for legal certainty, and I think your focus on that is terrific. Again, thank you for your efforts.
Thank you so much.
Thank you. Judge Liu.
Corey Liu from Travis County Civil District Court. A little bit of this is like us talking, but a little bit it's actually a question kind of from your vantage point. What is the selling point of the business court? But this, as some know, I'm transitioning from the Travis County case management system to self-district managed system, which is a loaded sentence. But moving on, just like things that I've observed now that I'm managing my own docket, I mean, the district courts are overloaded and overworked. I was talking to another judge, talking about having 10 or 30 trials set for 1 week. Obviously, the court can only be in trial for one trial that week. So it's constantly a process of people getting bumped over and over and over. And so from my perspective, I think there's value to have that the bandwidth and the talent of the business court. And so I think maybe because we were all appointed kind of around the same time, I do see you as my colleagues and want to support you however I can. So I think, as I've told you, privately, I'm committed to trying to transfer cases from the district court into the business court, which I think not as many district judges have been using, but I've encouraged, parties requesting it or judges sua sponte transferring. I will say, just looking at my docket of like 2,000 plus cases, there's actually not that many that qualify because it is such a small percentage. But then the legislature in the most recent September 1st bill that just took effect also allows the Chief Justice, I'm asking this because you're all here on one panel now, the Chief Justice of the Supreme Court can assign the business court judges as visiting judges to any district court. And I don't even think it's limited to business. It probably could just be anything you want, which was a constraining factor. But I think, certainly if you want to just decide a summary judgment or whatever, from my perspective, I'd welcome you to kind of come visit. And that's one way to both get you guys plugged in, another, first, hopefully in Texas law, to get you guys more involved in the community. But I think there is the demand, and so that's just sort of me talking to you guys, encouraging you to, let's continue that conversation. I hope we can to get you guys to Travis County Courthouse, deciding those cases, maybe getting more cases to you guys. The question for you is, like, from your perspective, I'm trying to think, what is the selling point of the business court, right? And just my very brief thoughts in like 2 or 3 cases in the last few weeks have been, I actually think in some ways maybe plaintiffs' lawyers might like it more because if you're trying to slow a case down and hope the judge doesn't have time to read, what's going on, right? The state court is, the judge just keeps bumping the case over and over. 3 years later, it's still not resolved. But if you have a really good, solid, powerful plaintiff's case, and the judge is on board and understands the importance of it, I assume it probably will move faster potentially. So maybe, I'm guessing the plaintiff's lawyer might like it versus the defense lawyer who knows how to play games and kind of slow it down. On the other hand, I think if you're on the defense side and you have very complicated arguments that could just knock out the entire case, a district judge maybe doesn't have the bandwidth or time to kind of dig that much into it. So I guess I could see reasons why different people might like it, but it's just, my general sense has been everyone prefers the judges they're comfortable with from their community who are elected. So there's always hesitancy to want to try to go to the business court. And the defendants don't like the idea of saying their case is a $5 million+ case. So there's just some resistance. But I'm trying to think, from your vantage point, who are the people who are going to end up in the business court who find it to be a preferable venue, and that's the selling point, and what, I guess, what do you tell people, in the bar?
I think you've covered it. Our best selling point is when I tell you your trial date is January 23, that's your trial date. It's nobody else's. You're not on my docket for a 2-week setting with 30 other cases I used to set in Harris County. I'm told it's 50 or 70 now for a 2-week docket, with no chance that a judge who gets graded on their dispositions, who will get 1 disposition for your 8-week jury trial on a complex business dispute when they could try 17 car wrecks in that time and get credit for 17 dispositions, much less the time. We've got the time that your case deserves and needs to give you. We got the time to give you the attention that your case deserves and needs. So I think that's a big selling point. You mentioned the legislative change that now allows us to take those pre-2024 cases that may have been in a district court, may still be years long in a district court, having trouble getting hearings, certainly having trouble getting the attention they think they deserve, now can transfer into the business court. That's because the legislature during the last session heard testimony in committee for case after case, complex business dispute where they got reset for trial, set every 6 months, never reached 6, 8, 12 times. And every time, and I was the in-house counsel reviewing and paying legal bills. I didn't have to keep my billable hours, but I had to review everybody else's. They don't tell you that when you sign up. But I was paying lawyers to prepare for cases they knew, I knew, everybody knew weren't going, and yet I had to pay them over and over again to prepare for trial. That adds up, and expense drives the resolution of these cases. I just can't afford to pay that anymore, so I've got to go to a mediator and settle that case, not on the merits, but just because I just can't keep paying over and over when there's no resolution in prospect. So I think that's not our only selling point, but I'd say it's one of our biggest.
We probably have time for one more question. Yes, sir.
All right, thank you all for being here. My question goes to kind of the 15th Court of Appeals as the direct line of appeals for the business court. There's going to be a lot of other cases in Texas that don't meet that $5 million threshold that still involve these business court type disputes, governance, or just contract interpretation. Do you foresee the business court's opinions and the 15th Court of Appeals opinions kind of leading the entire state. You know, the 14th gets an appeal, or there's a district court in Houston, they're going to look more to the 15th court and maybe reduce some of the circuit splits on these issues as well?
So that's a great question. I would say the leader in harmonization is going to be the Texas Supreme Court at the end of the day. Chief Justice Blacklock and his colleagues grade my homework. I, as an intermediate court justice, love when people cite cases from our sister courts that are well-reasoned, well-developed. I will, always look to a good Court of Appeals opinion if somebody's already looked at the issue. And so my hope is that, certainly as these issues percolate up, people will give us that same respect and look to our opinions as well. But just from the perspective of an intermediate court justice, it is amazing having opinions from a trial court. Getting an opinion written by the business court on an important issue, it's just a night and day difference. Because if you're familiar with Texas practice, if you're a judge, you're better off if you don't write on a summary judgment. If you don't give reasons, then you're not going to get reversed unless the appellant challenges every ground presented in the motion. There's a lot of disincentives for writing, which really makes my job hard. So I'm very excited to be seeing these writings come out of the business court, so that it gives us a good place to start. But before we close, I do want to say, all of us are setting up new courts. We're, solving challenges. We're building new things. It's a very exciting time. But one challenge that fortunately we don't have as we're trying to do all these new things is getting fair compensation. And so we all just want to thank Chief Justice Blacklock for the work that he did in this past legislative session to really move the bar on judicial pay for all of us, because we were 49th out of 50th. Out of 50 states, and it's just something we're all grateful for. So thank you.
Thank you. We're just about out of time. I guess I'll answer the last question that's probably on all of your minds, which is, yes, you should bet on Arch Manning. He's going to turn it around. The Longhorns are going to be fine, ride or die. All right. Enjoy the game tonight, and I hope you enjoyed the panel. Join me in thanking these distinguished panelists. Thank you.